The morning air in Tel Aviv holds a familiar blend of routine traffic and raised voices. Outside the Tel Aviv District Court, cameras rise on their monopods like periscopes scanning a choppy sea. Tripods lock into the asphalt. Reporters trade clipped updates with producers leaning against flight cases. Uniformed police manage a narrow lane through the crowd as court officers thread in and out of side entrances. On one side of the barricades, placards tilt toward the light, some denouncing the judiciary, others defending it. On the other, the courthouse facade stands impassive, absorbing the day's heat and yet another pivotal moment in a case that has threaded through Israeli politics for half a decade. A motorcade pulls in, doors open, security moves first, then the principal figure steps out, Benjamin Netanyahu, the serving Prime Minister of Israel, approaching the building where his legal fate continues to unfold. There is no novelty left to the choreography. Netanyahu has been here many times since indictments were filed in 2019 and his trial opened in 2020, but the stakes remain undiminished. The country's longest-serving premier is once again walking the narrow line between the podium and the witness stand, between political mandate and judicial process. Today's hearing, like others before it, is a reminder that the two arenas can collide, sometimes jarringly, on the same day. The scrum of shutters intensifies as he crosses the threshold. A few members of the crowd shout encouragement. A few others shout as loudly in the opposite direction. Inside, the courtroom settles into its formal rhythms. Lawyers open files. Court staff whisper confirmations of witness lists and schedules. A clerk checks the microphone levels. Whatever the news cycle has decided to emphasize outside, ceasefire violations, security consultations, coalition politics, inside the frame narrows to procedural matters, exhibits, questions, and answers. This case is not a single thread, but three, stitched together by time and consequence. Case 1000, involving allegations of illicit gifts. Case 2000, concerning alleged discussions of legislative or regulatory benefit for more favorable media coverage. And Case 4000, the most severe, centering on alleged favorable regulatory decisions for the Bezeq Telecom Group in exchange for positive coverage on the Walla News site. Prosecutors describe patterns. The defense denies them. Much of the country has heard the shorthand so often the numbers feel like brand names, but the details still matter, and they are revisited here methodically, one question at a time. As the session begins, counsel rises to confirm the day's scope. The judge marks the boundaries of testimony. The stenographer is already typing. Netanyahu's legal team has kept a steady posture throughout these phases, challenge the foundations, contest the inferences, insist on context. The prosecution, in turn, has maintained that the evidentiary chain, documentary, testimonial, and circumstantial, draws a coherent picture. Neither side is new to this room. Neither side betrays surprise. The Prime Minister's legal exposure is real, but so is the reality that he remains in office while contesting the charges. Over recent days, he has continued to handle government business, announcements, appointments, and security discussions, even as the courtroom calendar accelerates to multiple hearing days per week. The duality, once remarkable, has become routine. Cabinet on one day, court on another, sometimes both on the same morning. An emergency meeting with security officials can compress a hearing. An extended cross-examination can compress time for the cameras on the way out. Today is one of those overlapping days, with reporters noting that testimony is shortened amid new security developments and ceasefire-related deliberations. In public remarks over the past year, Netanyahu has framed the case against him as not merely unfounded, but politically engineered. During high-profile testimony late last year, he used a phrase that ricocheted beyond the courtroom: ocean of absurdity. Benjamin Netanyahu, Prime Minister of Israel. The words were as much aimed at a broader audience as at the three-judge panel before him. They still reverberate today among supporters who argue the justice system has been weaponized and among detractors who regard the case as a long overdue reckoning. Outside the courthouse, those two narratives collide in real time. Protesters opposed to the trial point to the country's security environment and argue that a sitting premier should not be distracted by court appearances, especially when major decisions are on the cabinet's table. Others, clustered a few meters away, counter that the rule of law acquires its meaning precisely when it is applied to the most powerful. They hold signs referencing the case numbers, the dates of filings, and the lengthy witness lists. The chant lines are short. The debate behind them is not. Inside, the day's questioning turns to sequences that the public has by now seen summarized many times. Who called whom, when, how a regulatory draft took shape, what a particular email chain suggests about intent, how a gift can be valued in money and meaning. Defense counsel presses witnesses on recollection. Prosecutors press witnesses on consistency. The court, as ever, seeks clarity in the fog of years-old messages and the imprecision of memory. At intervals, the story zooms out. The trial's timeline has overlapped wars, elections, judicial overhaul debates, coalition negotiations, appointments of key security officials, and a broad recalibration of Israel's regional posture. The Prime Minister's position is not in question today. The fact of his premiership is current and clear, but the courtroom nonetheless exerts its own gravity. The judges have no stake in ceaseless breaking alerts. The rules of procedure insulate the proceeding from the volatility outside. Yet the proceeding cannot entirely escape reality, not when counsel requests scheduling changes due to urgent meetings, and not when court calendars expand to 4 weekly hearings to hasten a case already years in the making. When Netanyahu has spoken about the balance between sovereignty and outside pressure, the line most quoted, especially in the Gaza context, has been succinct. Israel is a sovereign state. Benjamin Netanyahu, Prime Minister of Israel. That sentence has been deployed across multiple issues, but its subtext is consistent. Decisions in diplomacy, security, or law must be made in Jerusalem and Tel Aviv, not elsewhere. It is one of several soundbites that supporters have embraced as shorthand for a broader worldview. Today's courtroom session, though, is about narrower questions that cannot be answered by a soundbite. Did the acceptance of gifts create obligations? Did discussions with media proprietors cross a legal line? Did a regulatory process deviate in ways that cannot be explained by policy preference alone? The defense case argues that relationships between politicians, business leaders, and the press are complex but lawful, that prosecutorial theories read tendentious intent into ordinary interactions, and that policy shifts can reflect legitimate judgment calls rather than quid pro quo. Prosecutors argue that patterns of timing, access, and benefit speak for themselves. A senior legal commentator arriving for a later broadcast shrugs when asked for a simple answer. There isn't one. Legal standards do not weigh public impatience, nor do they resolve public cynicism. They ask a narrower question: has the prosecution proved its case beyond reasonable doubt? The courtroom silence that follows a sustained objection is the sound of the law insisting on its own tempo. During a mid-morning recess, Netanyahu's team confers at the far end of a corridor screened from cameras. Aides check their devices. Messages come in about the security meeting slated for later in the day. The country's top leadership is juggling 2 calendars, a ceasefire that is both fragile and heavily contested, and a trial that is both precise and sprawling. Journalists scribble notes for live blogs, the arrival time, the courtroom's mood, the visible interaction between counsel and client, the announced reason for truncating testimony today. For those who have covered every step since 2019, it is déjà vu, yet also undeniably new. The war is not the same as last year's. The political map has shifted, the docket expanded. Back in session, lawyers return to documents. The court takes pains to ground each question in a page, a date, a line. The value of gifts is recited. The negotiation of coverage is passed. Regulatory latitude is debated. The room is patient. It has to be. In white-collar cases anywhere, intent is usually the battlefield. The difference between persuasion and coercion, between flattery and consideration, between editorial discretion and directive. Here, those questions carry not only legal weight, but institutional implications. Where to draw lines in a political media ecosystem that is both small and intensely interdependent. When earlier testimony first began in December 2024, Netanyahu's framing of the case as politically motivated was not a surprise. It had long been his public position. The national divide that followed, protesters and counter-protesters at the courthouse steps, arguments about judicial overhaul and prosecutorial discretion, was also not a surprise. What has been surprising to some observers is how normalized the dynamic has become. The Prime Minister travels abroad, meets foreign leaders, announces appointments, and then appears before judges who will determine whether he remains not only a political leader, but a private citizen free of criminal sanction. Israel has lived with this duality before in other forms. Few expected to live with it for so long, so publicly. As the day unfolds, the other story tugging at the news cycle, the ceasefire's first phase violations and Israel's potential responses, keeps resurfacing. Editors debate whether it should lead security first or follow court first. For the government, both are first and both are urgent. Preparations are laid for an emergency consultation. Schedules adapt. The court, cognizant of practical realities, adjusts the day's plan. A brief announcement notes that testimony will conclude earlier than expected. Live blogs push the update, the feed refreshes. Outside, the afternoon light slants across the courthouse steps. The scene repeats. Microphones thrust forward. Questions layered on questions, a careful procession toward waiting vehicles. In place of comment, there is often only the briefest acknowledgement, a nod that signals attention rather than engagement. Lawyers, more talkative, remind reporters of the presumption of innocence. Opponents, more animated, argue that delay is the enemy of justice. Supporters counter that haste is its enemy. The crowd's rhythm is as steady as it is divided. What happens next? The court calendar suggests an intensified pace. Multiple hearings per week were ordered to keep the case moving, even as real-world emergencies intervene. The legal issues that remain are intricate but knowable. The political implications, less so. A conviction would trigger a chain of constitutional and coalition questions. An acquittal would prompt a different set of reckonings. A partial outcome, guilt on one count, acquittal on others, would ensure the debate endures. For now, all such scenarios are speculative, and the judges have signalled they will ignore all but the evidence before them. It is easy to summarise this moment as a collision of legal and political power. It is also incomplete. The trial is, on paper, about what happened in specific interactions, how a gift was solicited or accepted, how a conversation about coverage was framed, how a regulatory file was steered. But because it involves a serving Prime Minister, it is also about institutions, the credibility of prosecution, the resilience of courts, the accountability of elected officials, the role of media in a small but boisterous democracy. Each hearing adds to that institutional story, even when the headlines favour the day's flashes, the motorcade, the brief quote, the truncated testimony, the next meeting. In past statements, Netanyahu has emphasised national autonomy in the face of outside pressure. In one of those condensed summary lines that travel well across platforms, he made it plain: Israel is a sovereign state. Benjamin Netanyahu, Prime Minister of Israel. Supporters hear in that phrase a promise of steadfast leadership. Critics hear a cover for avoiding accountability. In truth, the court is neither for nor against the phrase. It is, in its own way, an expression of sovereignty, a legal process applied without exception. The courtroom empties. The plaza, though thinning, remains noisy with argument. A student group debates whether new legislation might affect the case. A former clerk explains why bills proposed to limit prosecutorial discretion are unlikely to alter proceedings already underway. A retired police officer recounts earlier anti-corruption cases, comparing investigative timelines and public reaction. A pair of tourists ask what Case 4000 is and receive a lecture that outlasts their patience. Everyone has become a minor expert in something. Everyone has a number, 1,000, 2,000, 4,000. That serves as a mental file tab for a nation's civics class in progress. Even for those who follow the case daily, the larger context keeps intruding. The government's security meetings later today will focus on reports that Hamas violated key components of the ceasefire's first phase. Israeli officials say they are weighing responses, including changes to control lines inside Gaza. These are not abstract deliberations. They involve maps, timelines, and lives. The court cannot absorb that weight, but it can make room for it momentarily by shaving an hour off the hearing. It is an imperfect accommodation, and it feels like one. Yet in a state pressed by emergencies, perfection is a luxury, continuity is the goal. As evening approaches, the courthouse steps reclaim their normal function, a transient place passed by without a second glance. The day's images are already archived, the footage captioned and uploaded, the transcripts queued for the next hearing. The law moves forward in clauses and commas. Politics moves forward in headlines and coalition math. Somewhere between the two are citizens trying to keep up, to keep faith, or simply to keep perspective. What is undisputed at day's end is the frame. Benjamin Netanyahu remains on this date the Prime Minister of Israel. He remains simultaneously a criminal defendant contesting serious charges. He maintains that the case against him is groundless. Prosecutors maintain the opposite. Earlier descriptions from the stand survive in memory and archive alike. Ocean of absurdity. Benjamin Netanyahu, Prime Minister of Israel. The more recent mantra, applied to questions from beyond Israel's borders, carries its own durable cadence. Israel is a sovereign state. Benjamin Netanyahu, Prime Minister of Israel. Between those two lines lies the work of the court. Slow, exacting, and in its best form, indifferent to slogans. Tomorrow, the docket will bring fresh witnesses or fresh documents or both. Tomorrow, the cabinet will contend with the ceasefire's next chapter or a different emergency. The institutional machinery of a democratic state, imperfect and resilient, will grind on. And at some point, whether weeks or months from now, a verdict will be read in a room much like the one that hosted today's questions. The country will look up from its screens. The plaza will fill. The microphones will be raised again. For now, the only words that matter are the ones entered into the record and the ones that can be sourced beyond doubt. The rest, analysis, argument, prediction, belongs to the conversations outside the frame. Inside, the court adjourns. Outside, the city resumes its constant motion. The motorcade slips back into traffic, a black line absorbed by the evening's flow.